Could you imagine being a juror and hearing that your son asked you to text you back and you didn't, presumably because you were all over adult friend finder or hanging out with horses? I mean, what's the jury supposed to think here? This is bad. Welcome back to the channel, everyone. Today, I'm reacting to the cross-examination of Jennifer CRUMBLEY. Just to bring everyone up to speed, Jennifer CRUMBLEY is being charged with manslaughter for the acts of her son, Ethan CRUMBLEY, who killed 4 of his classmates in 2021. The prosecution is claiming that Ethan's acts were foreseeable to her and her husband, and therefore could have been prevented.
My name is Jennifer CRUMBLEY.
And I'm a terrible mom.
I want to make sure that you understood the oath that you just took.
I do.
Okay, you understand that you took the stand under...
So, a lot of times attorneys will remind the witness of the oath they took, not just for the witness to hear, but also for the jury to hear how important it is to tell the truth. And to also remind the witness, like, hey, you're on a stand, everyone's staring at you, say the truth.
You have been described by your attorney as a hyper-vigilant.
Correct.
Okay, do you agree with that?
I do.
In fact, you called yourself a helicopter captain before.
Here's what's important to remember here. On cross-examination, the prosecution can only ask cross-examination questions in relation to the direct questions. That's really important. And a lot of attorneys talk about opening the door and being careful not to open the door. That's what they mean, because once you open the door on direct, you open the door for the prosecution to go in and basically ask anything they want, again, within the scope of that direct testimony.
Now, I'd like to talk to you about what your digital footprint shows.
Okay.
What the evidence on your phone shows.
Okay.
Nobody thinks about their digital footprint, your Instagram, your Facebook, your text messages. Just because something is deleted, it doesn't go away. Just because a picture is deleted, doesn't mean it can't be found. And a lot of the prosecution's angle in a lot of cases is to obtain all that information from somebody's phone. It's actually called a phone dump, because you're dumping out all of this information. A lot of defendants didn't even know it was there or forgot it was there.
Having horses is quite a time-consuming hobby.
It can be.
Okay? It was for you.
It can be.
And that's what you said yesterday?
Yes.
Okay. And you were at the barn for between 3 and 5 times a week?
See, these are leading questions. On cross-examination, they're allowed to ask leading questions. And that is, I'm telling you this is correct, right? You're giving the witness the information you want them to confirm. You can't do that on direct. And that's why cross-examination is such an important tool, not only for the prosecution, but for the defendants when they give the opportunity for cross-examination on a state's witness.
For a couple hours a trip?
Correct.
Okay. It's also an expensive hobby.
It is.
So your banking records show that in the year 2021, you spent over $20,000 on the horses. Is that correct?
Probably.
You see that? Banking records, they comb through each and every single one of her banking records. They're allowed to do that. They're allowed to tie those finances to a legal theory. And their legal theory here is, without even going too much into her testimony, is you were too busy on your horses and riding horses that you neglected your son, and that's why he did this. That's what the jury's hearing.
In fact, you told a coworker that half of your salary basically goes to the horses.
I might have, yes.
See how extreme that is? Half of your salary. If somebody's spending half of their salary on horses, then it's presumed that they're spending half their time with those horses. I love horses, but I wouldn't spend half my day with them.
And you would be in speed patrol between 1 and 2 times a week?
It's a total of 10 hours a week.
10 hours a week, okay.
I mean, she was prepared for that question because she knew exactly how many hours a week she was spending doing that. So that shows that her defense attorney prepared her for that question, which is hard to do. This is a little bit obvious because they're trying to paint a picture that she's spending her time doing all these extracurricular activities, but she was prepared for that question and she answered it with confidence.
But it wasn't just that, was it?
No.
In fact, there are numerous photographs.
See how her eyes are shifting?
sent to Mr. Milano.
She doesn't like the questions and she's trying to prepare herself for the
Yes or
answer.
no?
I'm sure it was.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday.
See what he's trying to do? He's hammering away at her previous testimony to show the jury, hey, she testified to you guys, and it's actually not true. That I would call a mistake by the defense attorneys because they brought it up, and I believe they brought it up in a way to show the jury, hey, she's putting all of her cards on the table. She did have an affair, but now the prosecution can ask anything they want in connection with that affair. She testified that she only met him 1 time a week at Costco, but that wasn't the case. It was much more than that. And now this prosecutor is going to lay out all those cards and show how deep of a relationship it actually was.
Was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included trips.
There were actual business trips that he met me on.
Okay. And it included other individuals.
She was prepared for that question
Yes.
too.
What's adult friend finder?
Oh,
Where you can go on and meet people who meet certain tastes that you're looking for.
This is 429. And you had the app, Adult Friend Finder, on your phone.
I do not believe I had the app on my
Okay, it
phone.
was found on your phone.
Okay, well, I guess it was on
There
my
it is. It was found on
And
your
there were
phone.
messages from you to other individuals.
Correct.
Good for you, Jennifer.
I would object. This is going outside the scope of the affair with Brian, but
I don't think the court's ruling on opening the door was confined to just her extramarital affair with Brian Welch.
well, I guess.
It always bothers me when judges say, I guess. Judges aren't supposed to guess. Judges are supposed to make rulings. The judge was just thinking out loud here. But again, what people are forgetting and sometimes forget is that the jury's listening. And when the judge says, I guess, tends to kind of make the jury lose a little bit of confidence in that judge. If I was facing 15 years for manslaughter, I wouldn't want the judge to guess, that's for sure. This judge is striking.
She depicted herself as having one extramarital affair for about a 6-month period of time. Where she met with him one time a week. That was her testimony yesterday. We have evidence. To
Again, the jury's listening to all of this.
On Adult Friend Finder, we see messages from you in at least of August of 2021, August the 4th, 2021.
Okay.
Okay, and you don't dispute August the 10th, 2021,
No.
August the 11th, 2021,
No.
and more importantly, November 21st, 2021.
No.
It's interesting because you could actually watch her breathing get a little bit more belabored
No.
with these questions, with each and every question.
I don't dispute it.
And you don't dispute that it wasn't just you and Mr. Walash meeting after work hours. It was with you and Mr. Walash arranged with other individuals to meet after work as well.
No, I only met with Brian during work hours. The times that we were at the hotel, I was on business. We did arrange for other people to meet us there.
So Sunday, November 28th, you remember that day? It was the day after you took your son to shooting range.
I don't remember it.
You don't remember that day?
No.
2 days before the high school attack?
No, I don't remember what I did that day.
Well, you were pretty specific in what you did on November the 27th with the firearm. You remember that?
Correct.
All right. Now, November the 28th, 2021, you spent your time arranging a meetup with somebody on Adult Friend Finder.
I never met anybody with an adult friend that day.
Arranging a meetup.
Oh, okay.
I'm not just talking about the time that you spent.
See, that's why it's very important to listen to the question. He asked her arranging a meetup, which means she was trying to coordinate meeting with somebody else. That's something that was opened up on direct, and this prosecutor is running with it. Why? Nobody likes a cheater, right? So the jury is now looking at this woman whose son killed 4 people, and she's a cheater. Where do you go from there?
With somebody. I'm talking about the time that you spent and devoted your energy to setting that up.
Okay.
And you'll agree with me, it's not just the time period at the Costco parking lot, or the time period at the hotel, or the time period on the trip, correct?
That's the only time I met with people.
Right. But that's not the only time that you devoted your own personal time and energy and focus to that, is it?
I guess I don't understand what you're asking.
Okay? Well, these meetups didn't just happen by themselves. You had to set them up.
Look at the level of uncomfort in the questions, but he keeps going because he wants to make her uncomfortable and he wants to break her. Look at her. She's wearing a nice navy jacket, big librarian glasses, her hair is down, she's not wearing any makeup. She looks like a nice person, but he's making it very clear to the jury that there's a lot more than what meets the eye here.
Correct.
You weren't driven there, you weren't dropped off there. You set them up with somebody else.
Correct.
And that took your time and your energy and your focus to do so.
Again, she was focusing on this and she wasn't focusing on her son.
Now, you told this jury that when your son texted you that he was seeing demons and bowls flying off the shelves, that was in the spring of 2021. You recall that evidence, right?
Correct.
You don't dispute that that was on your phone.
No.
You don't dispute that at some point you read those messages.
No.
And you don't dispute that your son said at least one time, "Can you please text me back?"
Correct.
You don't dispute.
Could you imagine being a juror and hearing that your son asked you to text you back and you didn't, presumably because you were all over Adult Friend Finder or hanging out with horses? I mean, what's the jury supposed to think here? This is bad. This is really bad.
When you're at the barn, your other messages show that you can take pictures, send pictures, and receive pictures.
Usually I'm at the barn. If I take pictures and I try to send them, they don't go through right away, or I won't send them until I hit a
Now,
stop.
here we go. I mean, that just sounds like an excuse to me. I feel like people use that excuse when they don't want to respond back to somebody after they've realized they got their text message but just forgot. Oh, I tried to send it, but it didn't go through. Like, come on.
So in Exhibit 423, the Facebook message chat between you and James, the chat that you deleted.
James is her
There are
husband.
a number of pictures that James sent.
Did you hear that? The chat that you deleted. That's the thing. People don't realize it. Just because you delete the chat doesn't mean it's not there anymore. And they found it, and look what they're doing. They're using it against her.
From the barn of a horse in a conversation about that particular horse. Do you
Okay.
dispute that?
No,
Okay. And in fact, dozens and dozens of pictures of the line.
I'm sure, yes.
You're sure? Okay. And those pictures were sent to you with a timestamp on that Facebook message chat.
Okay,
Do you dispute that?
no,
No. Okay. And then you responded in that same time frame. Do you dispute that?
no,
No. So that conversation with that picture.
See her movements? See how her eyes are shifting? See how she's kind of moving a little bit in her chair? All those little micro expressions, the jury's picking up on that, not in the sense of, oh, look at those micro expressions, just human behavior, human interaction. And all those jurors, they are staring at her. They're looking at every single reaction. I don't think she's doing well, maybe because I've seen tons of witnesses testify, but I can almost guarantee you that the jury feels the same way.
That was taken at the barn was occurring while one of you were at the barn.
I'm sure it was.
Okay. Now, you don't deny that your son wrote in his journal that he asked his parents for help. You don't deny that evidence that was admitted.
No, I don't.
Okay. And you don't deny that he wrote in his journal that he now had access to the 6-hour 9mm handgun.
I do not deny that.
And you don't deny that the 6-hour 9mm handgun was in fact the murder weapon.
I don't deny that.
And you also don't deny that.
Part of this line of questioning is to establish a narrative for the jurors. They're listening to all of this. They're piecing everything together because he's giving them the timeline to piece it together. Hey, there was a gun. He had access to it. He told her he needed help. All these things are being done methodically, systematically, and the jury's listening. They're listening, and they're looking, and they're paying attention.
That gun was gifted by you and your husband to your son on November the 26th.
Describe gifted.
How about when you posted on Instagram?
See, now she asked a question. Describe gifted. That comes off defensive. First of all, I would never allow my client to testify on a defense case. Here was unique, but typically you don't want your clients to testify. In a civil matter, when they testify, I tell my clients, don't ask questions. Attorney's asking you the questions. If you need clarification, ask it. But for her to come out and say, define gifted, that doesn't look good.
His new Christmas gift.
Correct. And I explained yesterday that it was for him to use at the shooting range. We didn't just hand him a gun as a here you go, son. It was something he could use when we went to the range as a family together.
You don't deny that in April of 2021, you described your son as being depressed.
I didn't describe him as being depressed. I noticed that he was acting
You
depressed.
used the word depressed.
Yes, he was acting sad. He was acting depressed.
Okay. And you know what depressed means?
It means a lot of different things.
Well, to you, it meant depressed, and you wrote that.
Right.
You don't deny in April of 2021, the evidence shows that your son told his only friends that he had asked you for help.
No, I don't deny that.
Okay.
See what the prosecution did there? He told his only friend. See how important the combination of words are? Now the jury's hearing he had one friend, and he told that one friend, I'm being denied help. And now that mother has to sit there and face those questions.
Well, your dad took your son with James to the shooting range when they visited in July 2021.
Correct.
And they talked about how powerful the 9mm was. Because they rented one.
I don't know.
Yes or no?
I don't know if I was part of that conversation, but if it was, it didn't register to me.
It was registered.
See, she didn't even really answer that question, but the jury heard it. What does the jury hear? That she knew that a 9mm was much more powerful than a 22mm, and she should have known or could have known. That's all they need to hear. That's all they need to hear. And then she went and bought her son a 9mm.
Why did you buy the Patriot defense rounds?
That was the ones my son told me to purchase. I didn't know anything about it. I'd asked him, and he told me to purchase them.
The gift was for target shooting only.
Correct.
Okay. Yeah, you bought 100 rounds of ammunition.
Correct.
And you only shot 50 while you were there.
Correct.
And those
See where they're going with this?
On November the 27th, when you came home, you posted pictures of the gun and targets to your Instagram account.
Correct.
And then according to the
See that digital footprint?
location data, you left.
And the location data,
think
so they
that's
knew
what-
what she posted,
well,
when
I
she
don't know.
posted
I
it,
must
and where
have-
she was when she
You don't
posted it.
deny
I don't deny it.
On Exhibit 74, here, I want to get back to this meeting. Right? Exhibit 74
If anyone's ever wondering how they show exhibits in court, nowadays it's typically just like that. There's a TV, fairly large TV, facing the jury. All the exhibits are labeled, and while testimony is given with respect to that exhibit, the jury's looking at it. So everyone's looking at it together.
Now, when we started, we confirmed that you understood the oath that you just took.
See how we went right back to the oath?
Yesterday.
Correct.
And you don't deny that you had $6,000 in cash in your purse the night you were arrested.
No.
You don't deny that your purse with the cash and 4 cell phones were in a plastic tote.
Correct.
You don't deny that that plastic tote was contained in a different plastic tote.
Correct.
You don't deny that your backpack with clothing items was found in a different plastic tote in a different area of that studio.
Correct.
See the questioning? He's outlining exactly how she was found when she was arrested. She was obviously trying to flee. She was hiding from the police. She had cash on her. She had burner phones. It was really clear that she was trying to escape. He's going to say that in his closing argument, most likely, but he can't just say, here's what happened. He has to get it out of her. So he's telling her, this is what happened, right? Obviously, she knows that's what happened. Obviously, she knows that all the police that were there had body cam footage, but he's just confirming, reaffirming, and confirming everything so the jury hears it.
Yes.
So it's important to note here that the prosecution gets to go last. It's the last thing that the jury hears. In fact, they have the opportunity to do a rebuttal to the defendant's attorney's closing arguments. So it really is the last thing that they hear. And that's exactly what's happening here.
We do get the last word.
See that? We get the last word.
The people do. It's our burden. And that's why we get the last word. And it's a burden I embrace. It's the burden to prove beyond a reasonable doubt that Jennifer Crumbley is guilty of involuntary manslaughter. It's not a burden that I have to prove every single fact about the case beyond a reasonable doubt. That's not the law. That's what she told you the law was. It's not the law. The law is I have to prove every element beyond a reasonable doubt.
That's the word that's important here. That's the operative word, reasonable. Was it reasonable for her to believe that her son could have done this? That's why the prosecutor's questions were so pointed and so direct, and every question had a purpose, and it's to go to that reasonable foreseeability.
I have to address a couple things, and I'm going to be quick. There was absolutely
Never believe a lawyer when you tell you that. I have to address a couple things, and it's going to be quick. It's never going to be quick.
Special Agent Brandon and Lieutenant Willis and the other law enforcement that took the stand here, including
What is it? What do you want?
Because I'm allowed to argue based on what's in evidence, and Miss McDonald is trying to make me sound like I've done something wrong. And I didn't. My argument was proper.
She's arguing. It's my remote.
Yeah.
That's why you have to be careful what you say, because it as an attorney, the other attorney can use it against you. Whether you're wrong or right, it can still be used against you.
Look at the evidence, apply the law, and decide what the truth is. That's all I've ever asked you to do. That's all the judge is going to ask you to do.
Simply put, is the best. A lot of attorneys forget that jurors are not attorneys. They don't understand legalese.
And I don't have to convince you of that, because I know that you're going to use your hearts and your minds and your sense of reason, and you're going to look at the evidence.
See that? Your sense of reason. Again, what's reasonable under the circumstances? What's reasonable under the facts? What's reasonable under the situation?
We have proven beyond a reasonable doubt that Jennifer Crumbley is guilty of 4 counts
See how she
of
keeps
involuntary
pointing?
manslaughter for failing to exercise ordinary care when the smallest, tragically simple thing could have prevented it.
I don't like to use paperwork when I give my closing arguments, but in her defense, there's a lot of information here.
It could have saved Madison.
See how she's saying the names to pull out the heartstrings of the jurors?
Tate. And it could have saved Justin.
It looks like they're putting their pictures up on that screen. In some states, that's not allowed.
She said she wouldn't do one thing different. When she took the stand and she testified about her own loss, and she was asked the question, "You lost everything," she said yes.
She didn't lose her son, though.
She hasn't lost everything, ladies and gentlemen.
See?
Her son is still alive. Find her guilty.
Excellent.
Involuntary manslaughter. Thank you.
See that? I mean,
Thank you.
That's a punch right to the gut. Can't come back from that. So a couple takeaways from this. Number one, if you're a defendant in a criminal case, you probably don't want to testify. But if you do testify and your attorney feels like you should testify, you have to be very strategic. You have to try to anticipate cross-examination as much as you can, and you have to be very careful on direct. The attorney has to be very careful direct examining you, because every question can possibly open a door. And the other part of this is you have to remember the jury is watching, they're listening, and everything you say or do during that trial is going to impact the jury. Whether or not that's negative or positive is up to them. If you like this video and you want to see more, hit the like button, subscribe, and comment down below with more videos you would like to see me react to.